versus Georgia, 1972. Background information. William Henry Furman was robbing a house and tripped and killed the homeowner with the weapon he was carrying, which happened to be a gun. He was found guilty of murder and qualified for the death penalty in the state of Georgia. Getting to the Supreme Court. This case made its way to the Supreme Court because it was similar to other cases such as Jackson v. Georgia and Branch v. Texas, in which those criminals were also sentenced to death. But this case was different because Furman never received his sentence, and his sentence was not carried out. This case was brought to the Supreme Court's attention because there needed to be a system in which the death penalty was carried out. Makeup of the Supreme Court. In 1972, at this time, there was no set laws for the death penalty and how it was carried out. The Chief Justice at the time was Warren E. Burger. Majority opinion. There was a 5-4 decision ruling that, according to the Constitution, the death penalty was a cruel and unusual punishment. To back up their case, they used the 8th Amendment and the 14th Amendment. The 8th Amendment. The 8th Amendment forbids punishment excessive to the crime with cruel and unusual punishments. In the case of Furman v. Georgia, Justice Brennan created 4 principles that determine what a cruel and unusual punishment is, using the 8th Amendment as a reference. Four principles. Because of this case, Justice Brennan created 4 principles that would determine what a cruel and unusual punishment was, referring to the 8th Amendment. A cruel and unusual punishment falls under one of the following: severe and degrading to human dignity, especially torture, infliction of wholly or arbitrary fashion, clearly rejected throughout society, and patently unnecessary. The 14th Amendment. The 14th Amendment has equal rights protections overruled by Dred Scott v. Stanford case, and protection within jurisdiction for racial segregation in the case of Brown v. Board of Education. Minority opinion. In this case, 4 was the minority in the final ruling. The justices in this minority were Justices Burger, Blackmun, Powell, and Rehnquist. These 4 argued that capital punishment was appropriate under the Anglo-American legal tradition and part of the Commonwealth law for serious crimes, in which our country had been using for so long, and they thought it was part of tradition. They also said that the Constitution gave the United States authority because of the 14th Amendment of taking life to give to the United States for the death penalty. Conclusion. Because of the rulings of this case, Congress rethought their statutes for capital offenses and that the death penalty would not be administered in a discriminatory manner. In the following 4 years after this case, 37 different states enacted new death penalties. But after these 4 years, in 1976, Congress, because of the case, Gregg v. Georgia, Congress deemed that the death penalty was in fact not offending the Constitution in any direct way, and the death penalty was put into play